Right, okay. Well, I'm here today with John Houghton MHK. By popular request, a lot of people, as we've just been talking about, a lot of the public feel like there's a lot more to this than meets the eye. And what I wanted to do, if it's okay with you, is we've just been talking about the technicalities of the Tynwald situation, but what I'd quite like to do, if it's all right with you, is go back a few steps, because everybody's got the impression there's a whole load more to this than meets the eye. So the first thing I was going to ask you is that this situation actually started in 2010, as I understand it. So there was a previous situation between the people involved in this, and as I understand it, at the time you were actually on the Tynwald Management Committee. So you were aware that there was a problem here, and there had actually been a previous investigation. So my first sort of question is, well, if that was the case, what led you to follow the course of events that you followed?
Right, yeah. What happened, very briefly, in 2012, actually, the same member of staff who I was representing in 2014,
Yeah.
Was cleared of an allegation that had no foundation whatsoever in her case of conduct. So I wasn't actually on the Tynwald Management Committee in 2012. I came off of it before the general election in 2011.
Right, okay. So, but as I understand, I mean, maybe well, this is a critical point then. In the evidence that's in the report, it's stated that the third clerk was accused of bullying by the person, Mrs. A, as she's referred to in the report, and that the third clerk was cleared of bullying. So is that not quite the case?
No, that has nothing to do whatsoever, James, with the original allegation that was made against the member's secretary.
Right. Okay. So, but yeah. So that's what one thing I picked up in the report. Then is there's a statement in the report by the third clerk that she had been accused of bullying by the member's secretary, and that the union had investigated it and found that there was no case to answer.
No, I can't really go into the ins and outs of that, because I can't even recall it myself, even if the member secretary, the former member secretary, can remember that. It's an area that goes back too far, to be quite honest with you.
Right.
And it's not really for discussion now, actually delving into anything in the past. I'm just saying that that's what happened, and if I can be helpful to you, what happened as a result of that in 2012 was that the Tynwald Management Committee wished to change the rules.
Yeah.
Members couldn't represent members of staff in which they always could.
Yeah.
What the Tynwald Management Committee did not do, and they failed to do, was see the whole matter through, whereby the staff handbook would have been amended,
right,
with their wishes in it. They weren't. So their wish was inoperable.
Right. Okay. So they tried to change it, but it wasn't actually enacted.
It wasn't enacted yet. It's inoperable. Because what happens is, if the Tynwald Management Committee wish to do something, first you have to negotiate with the staff unions and everybody else, and then bring forward the documentary change to the staff handbook, the staff's regulations handbook. Okay, in order for that handbook to be to be updated and become properly enforced. Because the staff handbook was never updated, the issue was never actually, if you like, concreted in for a member to cease representing a member of staff.
So were you involved in that process then?
No, I wasn't.
Right.
None whatsoever. No. Do you remember? This started in 2012. I came off the Tynwald Management Committee in 2011.
So were you aware that it had been changed?
They said that their wish, the Tynwald Management Committee said it was their wish that the members, that staff, Tynwald staff, should no longer, from 2012, be represented by members of Tynwald.
Yeah.
Okay. Now, at that particular point in time, none of the members of Tynwald were indeed informed. Members of staff may have been, but members of Tynwald may not. But like I say, there was no reference in their handbook disallowing them from approaching a member to represent them when they had been their integrity been challenged by the Tynwald by Tynwald management.
Because that's something it does say in the report, is that information was on their G drive, I think it's referred to, on their central computer drive, but as far as you're aware, that's not true.
That's not true. What's absolutely true is, and it's in the report, if you look at it in the report, in the small print at the back of the report, from the information that was provided by the original investigation officer, he provided evidence to state that the staff handbook had not been amended,
right,
to allow for that.
So to go back a step then, so prior to the events which unfolded at the end of 2014, you were aware that there was something going on. We don't, because I've tried to get hold of the report which dealt with that original situation, and it's off limits basically. But you were aware that there was something going on in the office between these people.
No, I wasn't. No, I was not, because I wasn't on the Tynwald Management Committee. I just represented a member of staff in 2012. As a result of that, I now know that they wished to change they wished to do away with
member of staff.
They wished to do away with the member of Tynwald representing the member of staff.
Yeah.
Whoever, doesn't matter, whatever member of staff.
No. The point I was trying to get to is that when this situation started to unfold at the end of 2012, what was your prior knowledge of the relationship between these two people involved? Nothing. So, I mean, one of the things that I also picked up from the report is that you made a statement to the effect that there was a systematic problem within that office, and that effectively people were being pushed out.
Yes, there was.
So the question in my mind at that point is, well, if that was the case, like, I'm just sort of, see if you can follow my thinking here. If that was the case, if I'd walked in and saw this person, or been involved with this person who'd been found to be upset, and I thought that there was a systematic problem within the office, would I have gone to their boss? This is the bit that I couldn't quite get my head around. Right.
Okay. Well, it's only right and proper if I can put it in simple terms as this: if a member of Tynwald, and in this case Mr. Wild, found a member of staff highly upset, okay, really upset, and of course he obviously went and comforted her and called me in to assist him, etc., etc. The only person that we could go to about that matter was the top man himself, and that was the clerk of Tynwald.
Yeah, that's the point. I mean, if you believe that there was a systematic problem in there,
we could do no other. You can only go, James, to the most senior member of staff. You couldn't take it anywhere else. It would be improper for you to take it anywhere else.
Well, this is the bit that I couldn't get my head around. Is whatever the situation was previously, there was a situation apparently that was dealt with between these two people by their union. And as you said to me on the phone, and again just now, when you're going to deal with an allegation of bullying, you have to have evidence.
Yes, thank you. Thank you. You've hit the nail on the head. You've absolutely hit the nail on the head. And so that's why there's no evidence whatsoever in that report that I've bullied anyone.
No. Let's not go on to you. Let's stick with them for the time being. Like, so you found this woman crying.
Yes.
And that's obviously
I didn't find her crying.
Well, yeah, sorry. She's been found in upset. Yeah. And I thought, well, to my mind, if you got the impression that there's a real problem in that office, what you need to do is get the evidence that she is actually being bullied, and take it to her union, because she is protected in law.
Yes, no, you are incorrect on that. You're completely out of the norm on that, James. I understand where you're coming from, but what you must do is, if you find an issue with a member of staff, the only appropriate thing that you can do is take it to the most senior manager. You can't do anything else. And what myself,
even if you think the senior manager is a bully.
Yep. Whatever you think, it doesn't matter. I had no thoughts on that line whatsoever. What I did, because that's the system that you'll find anywhere, certainly with members of Tynwald, it was only appropriate for me and Mr. Wild to have done what we did, which was go and alert the most senior manager in the building about what we had witnessed that happened. Nothing else.
Okay, well,
we can't divert to anywhere else, James. It would be quite improper to do so.
Well,
any of your people looking at following this interview would have to support that, no matter what.
Okay, but with the benefit of hindsight, do you think that a different approach at that point
couldn't have done anything other than done that? With the benefit of hindsight, and what a lot of hindsight.
Okay, so just to wrap up then, I mean, say we just discussing the way that the situation unfolded, and I had the impression, obviously, ignorance, the ignorant impression that it could have been handled differently because the person involved had legal rights to protection. So I mean that's just a matter of opinion really. I thought, well, if she's got legal rights to her job, if you'd collected evidence to support what had actually happened to her, it might have turned out different. But you see that differently. I mean, there really was no other way that it could have been done. It couldn't have been taken to the Tynwald Management Committee, etc., like that. So, I mean, moving on then to what happened to you. One of the things that's been flagged up to me in the last couple of days is that the standing order under which you were suspended was introduced in December of the same, after the in October, November, December.
Of which year are you referring to, James?
2014. Yeah. So the standing order, this is another thing that's been discussed online, is that, this is an ancient, ridiculous. And well, it wasn't. It was actually introduced immediately after
yes. No, I think,
what happened. And I thought, well, that's really odd. And
well, it might help to clarify a little bit about the ancient side of it. The investigation against me was done under the Tynwald Proceedings Act, 1876.
Right.
And the committee operated under 1876 procedures, procedures centuries ago, in the way they operated.
Yeah.
And that was not proper in this day and age, whereby you should have the right to appeal, you should have the right to bring witnesses, you should have the right to be represented, etc., etc., under natural justice.
So will you be
the issue
trying
coming
to change
back
that
to you,
then?
the issue coming back to what you're saying, James, and rightly saying, is whereby in 2014, and I'll leave it to you that you're saying that the issue whereby I had to either apologise or be suspended from Tynwald if I didn't, was a change in standing orders. Nothing to do with the procedures of the investigation, which were archaic, and Chris Robertshaw should have known better.
So two things there then. As I understand it, when it was changed in December, this must have effectively been as a consequence of what was going on with you, I assume.
No, you're talking about December 2014.
Yeah, when the standing order was changed.
Yes, but that standing order, all that allowed for in 2014 was that if a member who is found by the court and they vote for an adverse report, which was the adverse report that I was facing by the court, if that member then failed to apologise, the standing order stated that he is suspended from the court until such time as he apologises. Now, as there's a wide debate now going throughout the whole of the island, and actually some of it going into the United Kingdom, that standing order is completely out of order, isn't it, really? Well, because if you just take it to a criminal court just for a moment, and I says I wasn't guilty in a criminal court, not guilty, then you're found guilty, you're given a penalty, whatever that penalty is, right? But you can't be asked to apologise if you're saying I'm not guilty, and that's the issue here, James. I am innocent of this, completely innocent, and the report has no evidence against me whatsoever that gives strength in what those guys were doing against me. They just found it funny to have an adverse report sent to Tynwald against me in order to make me apologise, and of course, all the time, James, that I was defending myself, and finally defending myself in the statement I read out in Tynwald, saying that I'm absolutely not guilty. How can I then get up at the order of the President, after they voted for that adverse report, and ordered me to apologise?
Well, effectively you were given a choice in punishment, weren't you?
Correct. Absolutely. But I would have looked a fool. I'd have been a fool, and I wouldn't have been able to look at myself in the mirror in the future, in the fact that I've just spent 3/4 of an hour saying all the reasons why I'm not guilty, and I included in all of that evidence that you've now seen, and you've told me that your mind is in doubt, that now, with the actual accuracy and the integrity of that report, because of the evidence that I pointed to you and members of Tynwald during the day, that I gave my evidence, which stated that there was doubt in the integrity of the report using their evidence, not mine. And you've already agreed to that.
Well, you've very
James.
kindly given me permission to publish that along with this, which
What
I will
I'm
do,
saying
because
is that's
ultimately,
already in the public domain.
it's up to your voters really. That's where we
Yes.
come back to this issue
Yes.
of democracy and what's happened to
Yes.
your electorate at the moment.
Yeah.
So going back to the change that was made in December, as I understand it, you didn't vote against it at that time. Is there a reason why you didn't vote against that change?
Well, of course, you don't realise, James, when the Standing Orders Committee put some standing orders in front of you, I don't think any of us, until you actually go into that whole issue, which should have been gone into by those sitting around the committee table deciding upon that sanction, if I may put it that way, that it was quite improper and unfair to make someone apologise when that member strongly believes, as I do, that I am not guilty of the charges they preferred against me. Now, that's why I'm going to take this next to His Excellency the Lieutenant Governor after he's been sworn in. I may, if the Lieutenant Governor is unable to help me, take it to the Privy Council, but I certainly will be taking this further, and what I'm seeking is something quite simple. And that's for the matter to be re-investigated by a proper person.
I don't think anybody would have a problem with that, really.
No, and I agree with you. And I thank you for saying that, James. And before you ask that next question, you've had sufficient doubt in your mind of the integrity of that report. You've already mentioned that to me earlier. And because you've got sufficient doubt, I feel that many other members of the public, when they see the documentation, if they haven't already seen it, that you're going to put on the website, thank you for that, that whereby the evidence, not Mr. Houghton's evidence, but the evidence of others that they gave to the committee, including the missing statement that was conveniently missed out of this 400-page report, that incriminates Mr. Wild, okay, that Mr. Wild then needs to answer to a proper investigator about that matter and clear his own name. And I'm giving him the opportunity for doing that, because why, and I can only ask this question, not of you, James, but I can only ask this question, why was that vitally important piece of evidence excluded from the report when they had it? Because that's where I got it from. They started sending me evidence, further written documentary evidence, after I'd been interviewed by that kangaroo court committee, and I asked them, when I'd found Mr. Robertshaw was relying on documentation he hadn't pre-supplied me. They started then sending me papers in dribs and drabs through the ensuing weeks, and of course I uncovered this evidence, didn't realise at that time just how important that evidence was until I cross-referenced it against what these players were saying in their oral evidence and other documentary evidence.
But is there a reason that you didn't vote against the sanction when it was debated in Tynwald?
Well, the sanction when it was debated in Tynwald all that time ago is not that was unknown. The consequences were unknown to us. They put a number of standing orders for voting into the court all the time, and the thing is, perhaps any member may have looked at that and thought, yes, if somebody's done wrong, yeah, of course they should apologise. And actually, I would agree it. What if you don't?
Well, so go back another step then. As I understand, there was no other option really for Tynwald but to follow that set of rules, or was there?
There was no, since that standing order's been brought in, and that standing order, I can be assured now, James, will get changed. It'll have to be changed to govern the situation where I have a mandate from the public right up to the general election. I have a mandate to represent my public. I've got a mandate. I've got a mandate to look after my people, but properly represent them in Tynwald and the House of Keys. Now, there are only a short number of sittings left. There are only now, as we stand today being the 24th of May, that there's probably only 1.5 sitting days left of the House of Keys, because they break up for the Speaker's lunch on the last one. So there are a short number of those and 2 more sittings of Tynwald. So there aren't that many leading up to then, but those sittings are very important sittings, especially the Tynwald sittings, and especially the July Tynwald sitting. It's an important sitting of Tynwald that I am being deprived of, so the people who I represent are being deprived of their representative in there. Now, James, if we take all of this right into account, or no matter how it's serious, a serious charge against my integrity, a very serious charge against, and that's why I'll continue to fight until I get justice, because this hasn't been justice.
So was there any other procedure that they could have followed?
Yes, what they could have done, quite simply, is followed a modern day procedure of that. For instance, in the 19th century, they will have had a different discipline process than they have now. Under the Employment Act, if we compare it with that, there has to be a proper investigation, a disciplinary hearing. That hearing has to be fair, and the person who is being challenged can bring with him or her a representative. They have the right to bring witnesses, which I was given no right. They have the right to cross-examine, or the representative has the ability to cross-examine, and there's an appeals procedure. There was none of those, but had I sat in on a disciplinary procedure, because I've done it so many times, when I've been the chairman of the Civil Service Commission in the past, I'd have run to those appropriate standards, and those appropriate standards is to give a fair hearing to someone.
Yeah,
I would have done that to Mr.
I mean,
Robert Shaw. Mr. Robert Shaw didn't do that to me.
But could you have done without changing the rules? Could you have done? This is what
I would have changed the rules so that I could have done. Because
would that have required a change in standing orders?
James, whatever, they could have waited for a change of standing orders or a change of procedures, but no proper person, not any proper person, could have gone against you and said, no, you must meet out that archaic process, Mr. Houghton, when you're chairing a hearing into Mr. Robert Shaw. Because I'd have said, no, I absolutely will not, because it's quite improper for me to do so. And so let's change the standing orders or this, that and the other, and have them allied to the civil service procedures or any other procedures, because they're all of similar merit, these procedures, and done the job properly in a fair and balanced and impartial way.
So, I mean, in essence, the only reason this has never been questioned then is because it's never been enacted in living memory. The process that you went through.
No. What you've got slightly wrong is they're interviewing you under the Tynwald Proceedings Act, 1876. What I'm alleging that they've done, right, and challenging them for it, is they've operated under procedures of that century. That could have been changed. The Tynwald Proceedings Act doesn't actually need to cover the fact that you run under modern day procedures. No one can operate in such a way in this day and age. But sorry, I forget. One who could is Tynwald. Tynwald do what they want. When I asked the Attorney General about that, he gave us all a compromised answer, the Attorney General, when he said that Tynwald can do what it wants. I'm sorry, Tynwald cannot do what it wants. Tynwald must follow its own laws, and that's where they're going to be found wanting when I get them to that stage in the future. And James, perhaps at that stage, in the future, once I've got a right and proper investigation, that's going to show up Mr. Robert Shaw and his cohorts, as well as the others. That's why they didn't want that to support Mrs. Beecroft's amendment, asking for that. And the reason why they didn't do that is because they didn't want to be found wanting. So it's my job now is to make sure there's an appropriate investigation by a proper person, an independent person, who then will bring forward their judgment. I'll bet you that judgment will be quite different, right, to what these clowns brought against me. That'll do.
Okay. Thank you very much for your time, John.
Not at all. Good talking to you.